All
right, good afternoon. We are live on Facebook. Thank you for joining us today. My name is BJ Kilgore. I am an attorney in the Trust and Estates practice group at the Van Winkle Law Firm. I'm joined today by Lucas Moomaw, who is also an attorney in our Trust and Estates practice group. This is the 12th, I believe, in a series of live presentations that our group is giving on a variety of estate planning, estate and trust administration matters, and other related topics. Our discussion today is going to be on planning ahead for incapacity, and particularly using advanced medical directives, a healthcare power of attorney, and other similar documents in order to plan ahead for incapacity. Structurally speaking, we're going to break this into a couple of segments where we each talk about the relevant documents, the healthcare power of attorney, the living will, a HIPAA release form. But before we do that and get into some of the ins and outs, I think it's important that we give a little bit of a disclaimer on the discussion we're having today, and note that this presentation today is just solely about general North Carolina law. It is based on our own personal attorney experiences and practices. The presentation is not designed to be legal advice, and you should not take it as a recommendation for any personal particular situation. And you should always talk to your own specific attorney about your particular circumstances before relying on any general information, including this. With that sort of disclaimer out of the way, I will hand it off to Lucas to talk some about the particulars of the healthcare power of attorney in North Carolina.
Thanks, BJ. So the healthcare power of attorney is something you might be familiar with. It's a document that authorizes a person that you trust to make decisions for you related to medical treatment and other health services. The authority granted in this document to your agent is only granted once you're unable to communicate your medical wishes yourself. And so when you are no longer able to communicate these wishes, your healthcare agent would be able to speak with your physicians and with your medical providers and would be able to give consent for medical treatments and for withdrawing medical treatments, for instance, on your behalf. The healthcare power of attorney can be drafted as broadly or as narrowly as you wish. If you speak with an attorney to have that drafted for you, and you can give your agent in this document as much power as you're comfortable giving your agent. However, because your agent is effectively serving as your translator under this document, it is usually better to err on the side of giving more rather than less authorization, less power to your agent, just so that you don't get into a situation where certain powers are needed at the time and they're not authorized by the document. The most important thing, however, is that your document contains all of the provisions that you desire regarding your care, some of which might be related to specific medical conditions, health conditions that you have. If you already have a healthcare power of attorney and you're confused about any of the provisions when you get it out to look at it after this presentation, you would be well served to speak with an attorney if you have any questions. Because this document comes into power when you can no longer communicate, the time to clarify those concerns is now, when you can still communicate your desires. So I'd like to discuss some of the powers that can be granted in this document. Sorry, I think we're having an issue with the with the screen here.
Technical difficulties.
Okay, I think that probably looks better for everybody. So I want to go through some of the powers that you can grant in a healthcare power of attorney. I want to note that any of these powers that I'm about to list can be limited or omitted altogether. In fact, much of the substance of the power of attorney is contained in these limitations, where you can specifically limit your agent's powers. The first power, and probably the most commonly used, is your agent requesting, reviewing, and receiving any information about your physical and mental health, including your medical records. Your agent can also be given the authority to disclose the information to other people in their discretion. Your agent would also be able to hire and fire your healthcare providers to the extent that that becomes necessary. They could also consent to your admission and discharge from hospitals, nursing homes, hospice, mental health institutions, really anywhere you're receiving care for a medical related issue. They can also consent to very specific treatments, such as electric shock therapy. That's one thing that the document lists. They also can give consent for surgery, anesthesia, medication, any treatments by a physician. And they can authorize the withholding of life support. BJ will discuss in a little while how this interacts with a document called an advance directive, also known as a living will, where you personally make decisions regarding your end of life care before you become incapacitated. Another thing the agent can do is authorize autopsy, organ donation, and handling of your bodily remains. And they can also grant releases of liability to medical professionals by signing waivers. So one of the most important considerations in a healthcare power of attorney is who you select to be your agent under the healthcare power of attorney. Given the nature of the agent's job, which is to speak for you when you can no longer speak for yourself, it is extremely important that you give careful thought to who you want to act as your voice in these medical care situations, some of which can be very time sensitive. One of the restrictions on who you might be able to pick as your agent can come under state law. So in North Carolina, for instance, your agent does have to be over the age of 18. And other states have different restrictions. So you should definitely speak with an attorney in your state to the extent you're not in North Carolina. And even if you are in North Carolina, speak with an attorney about these restrictions. You can list one or more agents in your document. Generally, we advise clients to pick at least one healthcare agent and at least one backup healthcare agent who can serve as a successor in the event that your first choice is unable or unwilling to serve when you need the help. The healthcare power of attorney has contact information for each of these agents so that medical professionals can reach them when it becomes necessary. We do have some clients that want to list more than one agent to serve at the same time as co-agents. This might come up where somebody wants two of their children to make decisions together. People should be careful about doing this because if your two agents disagree, say your two children disagree, and meaningful time can be spent on them essentially deliberating about the decisions to be made regarding your care, when really it would be more efficient and less risk for you and for your health if you had picked one person that wouldn't be engaging in this deliberation, which essentially causes that person to be ineffective as a lobbyist on your behalf. In any event, you should give as much consideration to picking your backup agent as you give to picking your primary agent. Some of the considerations that I think are quite important when you're picking an agent, I'm about to go through a few of those. The characteristics that make for a good agent. The first one is that you find this person to be implicitly trustworthy. You should feel confident discussing your wishes for medical care with this person. If this person disagrees with your specific wishes, you could potentially still pick this person if you're confident that he or she would put your wishes first and their personal preferences aside in order to ensure that your determinations about your health can be made even once you can no longer communicate those. It helps to have a strong-willed and assertive person performing this role. your agent might be put in a position where they need to strongly assert your wishes in this medical establishment, which can at times be stubborn depending on who you're dealing with. And also against other family members who might disagree with your beliefs and your interests and push back against the agent, although they are simply reflecting your wishes and acting upon those. This person really should be your number one advocate when you can no longer communicate for yourself in the medical environment. Another characteristic that makes for a good agent is if you have a financial power of attorney, and that's a completely distinct document. We have a presentation on the Facebook page from a few weeks ago discussing financial general powers of attorney in specific, if you have more curiosity about that. But if you've named an agent under a financial power of attorney, it can be helpful to pick the same person actually to serve under your healthcare power of attorney. Situations could potentially arise if you don't do this, where your financial agent could resist paying medical bills, for instance, and could impede the performance of the healthcare agent, which is not something that you would want. Finally, a pretty important characteristic of a healthcare agent is that they live geographically close to you. It's not a requirement by any means, but it does help in situations where you might have an illness that lasts for a long time, and your agent might need, therefore, to be close by for weeks or months at a time to make sure that your medical professionals are meeting the wishes that you articulated in your healthcare power of attorney. I'd like to go through just some tips that can make this healthcare power of attorney as effective as it can be for you. Consider your particular health conditions and concerns and try to tailor your document to make the handling of care for these conditions explicit. Everybody's health is different, and so everybody will have different requirements and different desires for specific health issues. As I mentioned earlier, be sure to list at least one backup agent and stay on top of the contact information for all of the agents that you list in your document, so that your healthcare professionals don't end up spending valuable time that they could be caring for you by tracking down your agent. So if your agent's contact information changes, be sure to go back to your document and update that for efficiency's sake. Be sure to have discussions with your agent about how you want them to interact with medical professionals and how you want them to fulfill your desires in this document. The document can only go so far as its own language, but if you can sit down and have discussions with your agent, it can go a long way in ensuring that your document is used in the way that you would like it to be. Your document might also include a place, in fact, it's common that it would include a place for you to give the names of physicians who are given the role of confirming that you lack the ability to communicate your own decisions, which is, of course, the triggering event for the healthcare power of attorney to spring into action. The upside of naming a physician in this blank, it's usually a blank that you can fill in, is that you could rest assured that your physician is somebody you know and trust, and that physician might also have a more subtle understanding of your particular medical conditions and when those get to a point where you can no longer really communicate. The downside of naming a physician in this place is that if your physician is somehow on vacation or difficult to reach otherwise, again, this could waste time when it might be better for your attending physician to make this determination that you don't have the capacity to communicate, so that your healthcare agent can start making these important decisions regarding your care. So overall, for efficiency reasons, it's probably better to leave those places blank unless you have very specific concerns that a physician that you know and trust is the only person to decide when you lack capacity. Otherwise, having your attending physician make this determination is probably a better way to go. One question clients have about their healthcare documents in general, but certainly about the healthcare power of attorney, is where to store the healthcare documents. What you would want to do is give each of your agents a copy of the healthcare power of attorney, and also place the healthcare power of attorney on file with your primary physician, and also at any hospital where you think you might end up needing treatment. People usually pick their local hospital for this purpose. You also have the option of filing your healthcare power of attorney with the Secretary of State. This is less common because people, if they do this, need to be comfortable that the information contained in the healthcare power of attorney and the authority that's given to the healthcare agents is in the public record and searchable by the public at large on the internet. Finally, I want to discuss how you can revoke this document. You can revoke your healthcare power of attorney in writing by verbally communicating your intent to revoke, or that can be done by speaking directly to your agent or to your healthcare provider. I'd like to turn it over to BJ now for a discussion on advanced directives, which I referenced earlier. They're also known as living wills. BJ?
Sure. So Lucas covered a lot of ground there on the healthcare power of attorney. The living will is a shorter document most of the time. I think, kind of from a broad perspective, when we're talking about a living will, it is important to, number one, define what exactly that document is. As Lucas mentioned, it's an advanced directive, also referred to as a living will, one and the same in this case. Determine when that document applies, what is the context for when that one matters. And then, really recognize what that document gives you the ability to do, how you can express your wishes and thoughts about end-of-life care within that document. So first, what is a living will? Basically, a living will is a legal document that allows an individual to specify what his or her wishes might be in terms of life support, life prolonging measures, or the removal of life support or life prolonging measures within the context of an end-of-life circumstance. To most people, this is a document that is kind of defined or known as the sort of pull the plug document, for lack of a better word. In North Carolina, as I believe it is in most states, this is a state form. It is a form that is essentially crafted by the state legislature. And most of the time, practically all the time, we are not really deviating from that state format. You could deviate from the state format, but I think there's a practical reason not to do that, which is most of the doctors, most of the medical providers and hospitals that will be ultimately reviewing this document are familiar with the state format, and they see it all the time. And so by altering the terms of it or providing them with something that is a little bit new or unique, you could run the risk that they don't immediately accept it or understand it, which might result in some delay when medical decisions are really necessary and important. And most of the time, those decisions need to be made pretty quickly. Now, the form itself is somewhat bare bones and does really just give an individual the ability to select how they want to be treated in terms of life support, life prolonging measures, and also whether they want to receive artificial nutrition, hydration, things like that. It doesn't give a whole lot of room to bring in other information or other specific desires or requests that a client might have during an end-of-life scenario. And so oftentimes we will get the question from clients or a request from clients that they have a variety of different things they would want to be done when they are in one of these circumstances. And usually what I'm recommending to them in that situation is not to alter the living will format, but perhaps to include those directions in a healthcare power of attorney, as Lucas mentioned earlier. Or another alternative to that would be to create a separate kind of a side healthcare memorandum or healthcare letter that expresses that client's wishes for a variety of different scenarios and wants and needs in that circumstance that could be attached to the living will or could be attached to the healthcare power of attorney. And then a third option, and maybe the most informal of the options, is simply to communicate those instructions to your healthcare power of attorney, preferably in writing, but at least verbally as well, so that they can direct your medical providers to follow your wishes. So that is what a living will is, the gist of it. I think it's also important to recognize what a living will is not. A living will is not the same thing as a do not resuscitate order. They are often confused for one another, and understandably so. But a do not resuscitate order is something that has to come directly from your doctor's office. I believe, and my understanding is, a do not resuscitate order can only be issued by a doctor when you already have some sort of terminal condition. Now, they are very similar in the material that they cover, but I think probably the best way to distinguish the two types of documents is that a do not resuscitate order is essentially a document that is giving your medical providers instructions on when they can, or really when they cannot, bring somebody back. On the other hand, a living will is a document that is instructing your medical providers and your healthcare power of attorney, for example, as well, when they can essentially let somebody go and remove life support or life prolonging measures. A living will is also not a last will and testament. They have similar names, but they cover vastly different grounds. A living will is solely a medical document, while a last will and testament obviously deals with the disposal or disposition of your property and the appointment of somebody to administer your estate. So that's what it is and what it's not. I think it's also important that we understand the context of where this document applies, because it's pretty narrow. A living will, unlike a healthcare power of attorney, is sort of subject to a very particular set of circumstances. That is, your doctors and medical providers have already determined that you are incapacitated and no longer can make your own medical decisions or communicate those decisions. So that's number one. Number two is that they have also determined that you are in an end-of-life circumstance. They have determined that you have an incurable or an irreversible condition that you're not going to recover from, that you are in a permanent coma, that is, they've determined to a high degree of certainty that you're not going to come out of, or that you are in the advanced, end stages of dementia, cognitive loss, Alzheimer's, something along those lines. So that's the context. You're in that scenario, and I want to be clear that this is not a document that applies, merely when someone has normal dementia. It's not end of life stages, or a document that applies merely when you've been diagnosed with some type of disease or illness. It is truly designed for the end of life, when death is likely imminent. And within the context of that, the document itself gives the individual who's filling it out the ability to make certain decisions about how or when end-of-life care and life support should be stopped. If you saw the document, it's basically a form that you go through and initial your wishes, and probably the most important of those decisions that you make within that document is whether you are potentially authorizing your medical providers and your healthcare power of attorney to remove life support or life prolonging measures, meaning you have selected in that document that they may withhold or withdraw life support. On the other hand, you have the option of selecting that your medical providers shall withhold or withdraw life support. First thing to say there is no right or wrong answer. Clients vary, their wishes vary, and so you're not going to go wrong by picking one selection or the other. If you're looking at it kind of a pros and cons type approach, if you select may, that's obviously the more flexible, more discretionary option. Clients sometimes like that because it applies some flexibility to unknown circumstances. it also really and largely puts that decision in the hands of your healthcare power of attorney. On the other hand, the shall option, the shall withhold or withdraw life support, is more definitive. And you are, in essence, taking that decision out of the hands of your medical providers and your healthcare power of attorney and making it yourself. Clients often like that because it's pretty clear what your wish is, and also because they may be removing a potential burden from a loved one or a friend or a family member who is serving as your healthcare power of attorney. The other thing a living will can do briefly is it is a document that also allows you to specify your wishes in terms of receiving artificial hydration, nutrition, or both, or none of the above. You could leave it blank, in which case your healthcare power of attorney basically has the option of authorizing or not authorizing those types of treatments. That's a quick overview of the living will. I know we're running a little bit short on time. Lucas is going to talk maybe real briefly about HIPAA release form, and then I'll give a very, very brief synopsis on how these documents interact with each other.
Thanks, BJ. Yeah, I'll speak briefly on the HIPAA release form, which is commonly just known as a HIPAA. You might have heard that in the past. This is a document where you can provide authorization to your medical professionals, such as your physicians, to speak with people besides yourself about your health, and also to provide any paperwork, any medical records about your health. There are a few considerations to think about when you're naming individuals to your HIPAA release form. First, you can name as many or as few individuals as you would like to have access to your medical records. One thing you should consider is whether you want all of these people to have access to your records at any time, or whether you would like these people to serve sort of an order of priority, where the person at the top of your list has access to your records unless they're unable or unwilling to be helpful in that role anymore, and then the person just behind them could have access. So that would be a one at a time sort of situation. These are both valid options. It really just depends on your comfort level with the individuals that you pick to receive this information or speak with your healthcare professionals. Another thing to consider here is whether you want the people on your list to have access to speak with your doctor and get your medical records at any time, or only once you become incapacitated, which is, of course, when the power of attorney, healthcare power of attorney would trigger. This document, this HIPAA release form, should definitely be on file at your doctor's office, just to reduce the possibility of logistical problems if there's something time sensitive and you need one of the people named in your document to get some information for you or for themselves, and it's not on file, and then the doctor's office ends up spending too much time trying to track down this individual or to track you down to get your consent. Finally, to the extent that you go through a divorce or end up having substantial conflict with any of the people on your HIPAA release form, you'd be advised to create a new HIPAA, removing and possibly replacing the individuals that you're in conflict with. Otherwise, they would still be authorized to access your sensitive information, and they could potentially use this against you, which is a risk that nobody really wants to go through. I think that'll do it for HIPAAs for now. BJ, I'll turn it back to you, and you can discuss the interactions between the documents that we've discussed so far.
Yeah, so as you might imagine, these documents overlap at times. That it's really easy to describe how the HIPAA form overlaps with these other documents, in that the HIPAA form is just granting access to your private medical records. And, you might imagine that your healthcare power of attorney, whoever is making your medical decisions, is going to need and want certainly access to those medical records in order to make informed decisions. Where it's a little bit more complicated is how the healthcare power of attorney and the living will interact with each other. And it's probably best to think of it as the healthcare power of attorney is the broadest of these documents, and maybe the living will is one that fits within the circle of the scope of issues that the healthcare power of attorney might cover. or as example, as a timeline type of example, the living will is only going to cover that small slice of territory that the healthcare power of attorney covers at the end of life. But in those scenarios, they do overlap, and it could lead to some potential, crossing of wires or conflicts. And I think that's probably best described by a couple of quick examples. One is in your living will, as we talked about earlier, you have gone through and selected, the shall decision, the shall withhold or remove life support. But you also have a healthcare power of attorney, and you could foresee a hypothetical scenario where you've said no life support, but your healthcare power of attorney, for whatever reason, maybe its circumstances are different, or it's a situation where they want to allow some limited life support to allow friends or family to come and say goodbye. Your power of attorney may disagree with your decision to prevent any additional life support or life prolonging measures. And so you've got the potential for a butting of heads there. And it's really resolved within the terms of the living will, if you have one. And there is a section within that document where you can essentially decide in that conflict scenario whether you want your specific written instructions in the living will to override your power of attorney or vice versa. If you select follow the living will, then that's what is going to happen. And your medical providers are directed essentially to ignore your power of attorney if they are saying something different in that limited context. On the other hand, you could allow your agent, your power of attorney, to override your selection, which does give it a little wiggle room, and is almost like saying may, except there's a more particular set of instructions related to your intent. And also, you're not necessarily putting the burden in the hands of your power of attorney to make that call unless they actively go out and seek it by overriding your selection. The other example is a little bit more straightforward, where you have selected may in your living will, may withhold or withdraw life prolonging measures. If that was your decision, I think you are almost inherently already saying that you want your healthcare power of attorney, of course, in consultation with your medical providers, to make the determination about when to stop or remove life support. They do cross over in a few different areas, but we're a little short on time right now, so I'm going to start to wrap it up and just say, if there are particular questions that you have about this, feel free to reach out to us on Facebook, post the question, or contact our office. This is not the last in our series. We will be back, not me personally, or Lucas personally, but next week on November the 10th, Brian Lawler and Heather Goldstein from our office will be doing another presentation on paying for long-term care without breaking the bank. And I would hope everyone would join us again on November 10th. That's all I have to say, and nice to see everybody today in a sense. Thanks.